May it please the court, my lord, I will present to you as the court the response of the defendants. On 31 December 2020 at 13:41, the plaintiff received the response from Madoda Titus, advocate Madoda Titus, and then the state attorney Nonyani Sogoniwe, in which it is stated that dear Mangolele, kindly find attached here to a copy of the defendant's notice of intention to oppose this matter. Kindly confirm receipt hereof per return on behalf of Ms. Nonyani Sogoniwe, State Attorney. Kind regards. Madoda Titus is BALLB Rhodes BCom Honours Tax UNISA, advocate of the High Court of South Africa, practicing member of the Cape Bar High Court Chambers Group 1 at first floor Velocity House, 30 Kerom Street, Cape Town, 8001. Is contactable on 021 817 6799. Cell phone is 083 593 3238, and fax mail is 021 424 and email is at madoda@capebar.co.za. with that particular website address of www.capebar.co.za. In the High Court of South Africa, Western Cape Division, Cape Town, case number 19275 of 2020, Lieutenant Commander Sylvester Vulani Mangolele, the applicant, and the state, the first respondent, the President, the second respondent, Minister of Defense, third respondent, Chief of the South African Navy, fourth respondent, Officer in Charge Lexato, fifth respondent, Mr. Marcel Divert, sixth respondent, and Minister of Police, seventh respondent. Notice of intention to oppose. Kindly take notice that the first to seventh respondents hereby gives notice of its intention to oppose the above application and has appointed the office of the State Attorney, 4th floor, Long Street, Cape Town, at which they will accept service of all documents in the proceedings. Office of the State Attorney, Per N. Goniwe, and contactable at 021 441 9200. Dated at Cape Town on the 31st day of December 2020, the State Attorney, Nonyani Sogoniwe, Attorney for Respondent, 4th floor, 22 Long Street, Cape Town, reference NG/20/P22. To the Registrar, High Court, Cape Town, and to Sylvester Vulani Mangolele, contact details 084 835 9161 as the cell phone number, and email address at lengolisto@gmail.com. My Lord, it is attached as proof that in the High Court of Western Cape Division, Cape Town, case number, as per the record of court, a PDF was received, and then a response from the plaintiff was sent, in which he says, "Good day, I herewith acknowledge receipt. Regards." And then in return, this particular acknowledgement of receipt was done on the 2nd of January 2021 at 1938. On January 4, 2021 at 10:28, the Office of the State Attorney responded as follows. Dear Sir, kindly find the notice in terms of Rule 32B of Uniform Rules of Court. Kindly acknowledge receipt thereof. Regards. In the High Court of South Africa, Western Cape of Cape Town, Western Cape Division, Cape Town, in the matter between Lieutenant Commander Sylvester Vulani Mangolele, the plaintiff, and then the state, the first defendant, the president, the second defendant, Minister of Defense, the third defendant, the Chief of the South African Navy, the fourth defendant, Officer in charge of Lexato, Cape Town, the fifth defendant, Mr. Marcel Devet, the sixth defendant, Minister of Police, the seventh defendant. My Lord, you will notice the mistake being corrected by the defendants themselves in accordance with the record of court, as opposed to the notice of intention to oppose, where the misrepresentation was of the respondents, as is displayed on page 85 of the record of court, my Lord. When the court compares page 85 and its contents and page 89 and its contents, it will see the discrepancy that one is referring to. In the notice in terms of Rule 32 Bravo of the Uniform Rules of Court, be pleased to take notice that the first to seventh defendants hereby give notice in terms of Rule 30 of the Uniform Rules of Court that the plaintiff notice of motion and the founding affidavit dated 30 December 2020 and filed in support of this application constitute an irregular step for failure to comply with the Uniform Rules of Court, the rules, for the following reasons. Service of the process initiating the proceedings. The documents initiating the plaintiff's process in these proceedings were not served upon the defendants by the sheriff of this court, but by the plaintiff personally. However, Rule 41A and AA provide that such service shall be effected by the sheriff of this court. Thus, the plaintiff's service of the process as aforesaid amounts to an improper and impermissible service. Therefore, the service by the plaintiff constitutes an irregular step for failure to comply with the provisions of Rule 41A and AA, and accordingly is a non-starter. Plaintiff appointment, service address. The plaintiff has not set out an address within 8 kilometers of this court where he would accept service, but merely set out his cell number and email address. Rule 65B provides that an applicant shall appoint an address within 8 kilometers of the office of the registrar at which he will accept service of all process in the proceedings. The plaintiff's failure to furnish his address within the aforesaid distance from this court is impermissible. Therefore, the plaintiff's notice of motion constitutes an irregular step for failure to comply with the provisions of Rule 65B. Agency. The plaintiff brought his application on an urgent basis. The plaintiff avers that his cause of action inter alia is based on his arbitrary deprivation of his salary since August 2018. See paragraph 5(1)(f) at page 30, read with para 25 of founding affidavit at pages 41 and 42. And a period of 28 months has lapsed since the aforesaid deprivation. See paragraph 5.5 at page 31. Rule 612 Bravo provides that in any affidavit filed in support for an urgent application, the applicant shall set forth explicitly the circumstances which he serves renders his applications urgent, and the reasons why the claims that he could not be afforded substantial redress in the hearing in due course. The plaintiff has failed to set out explicitly the circumstances that renders his application urgent and the reasons why he cannot be afforded substantial redress at the hearing in due course. More specifically, in light of the existence of the delay 28 months, which is his own version, had lapsed since his cause of action arose on 8 August 2018. As required in terms of the provisions of Rule 612B of the rules, therefore, the plaintiff's affidavit fails to comply with the provisions of Rule 612B and constitute an irregular step which must be cured before the matter may be deemed to be ripe for hearing. Please take further notice that the first to seventh defendants hereby affords the plaintiff a period of 10 days within which to remove the cause of complaint referred to above to the extent that is possible in law, and that if the plaintiff fails to remove the aforesaid cause of complaints within the aforesaid time period, the first to seventh defendants intend to apply to the above mentioned court in terms of Rule 31B and 30A2 to have the plaintiff application set aside in its entirety with cost. Dated at Cape Town on this 4th day of January 2021 by the State Attorney N. Goniwe, Attorney for the 1st to 7th Defendants, 4th floor, Liberty Center, 22 Long Street, Cape Town. With contactable number, as already said, and the fax number 0214219364. This was sent to the Registrar High Court, Kerium Street, Cape Town, and to Sylvester Vulani Mangolele, cell number 084, as already said. My Lord, the plaintiff responded on January 4, 2021 at 14:05 to say good day. Receipt of the notice in terms of Rule 32B of Uniform Rules of Court is herewith acknowledged. We shall meet at 0945 at the chambers of the presiding officer for introduction before the matter is heard at 1000. Kindly advise who the presiding officer is, as I have not received any correspondence from the registrar in relation to the urgent court roll that was supposed to be sent sometime after Thursday 1200 to now. Regards. An advocate, Madota Titus, responded on January 4, 2021 at 15:35 to say, Dear Sylvester, thanks very much for your email. Confirm receipt of the notice. Unfortunately, I do not know who is the agent judge for tomorrow, and I am certain that we will find out tomorrow morning from the registrar when we arrive at court. We will see you tomorrow at the steps of the High Court at 0945 accordingly. Kind regards. And attached on page 96 of the record of court, my lord, is an email from the plaintiff and to the parties, including the vice president or the deputy president, the deputy judge president of the Western Cape High Court, the Honorable Goliath, the judge president of this High Court of the Western Cape, the Honorable Judge President Hlope, through his secretary, Lizette Potgieter. The General Office at the Constitutional Court was also informed in their email through including the registrar, Mr. Makhacha, being notified, and Mr. Mabatu Ngobeni, including the African Transformation Movement Party, including the senior military judge, Colonel Rian Combrick. Lexato Cape Town was also informed. South African Navy, the Office of the Chief of South African Navy was also informed. The family of the plaintiff was also informed through the brother Letlohonolo Ineth Mangolele. And then the Free State Province Organized Crime was also informed at the South African Police Service. The South African Human Rights Commission was also informed through the email at complaints. And the Judicial Service Commission was also informed through their email complaints, and the Speaker of Parliament was also informed of the matter. The Deputy Speaker of Parliament was informed. The Secretary to the Portfolio on Defense Committee, Mr. Brian Manji, was also informed. The chairperson was also informed. Mr. Kaso, as the Secretary of the National Assembly, was also informed. Corruption Watch was also informed through corruption reports at saps.gov. The Supreme Court of Appeal was also informed. AfriForum was also informed through Advocate Elijah Mamabolo. And the Supreme Court of Appeal was also informed of this matter. This was on the 5th day of January 2021 at 12:41, wherein the plaintiff says, "Good day, Judge President Hlophe and Deputy Judge President Goliath. You are called to uphold the supremacy of the Constitution and the rule of law to ensure that the Western Cape Division serves justice to all. The court has issues the matter, and people inside the court are obstructing the administration of justice to make sure that others do not account for their actions. I come to court and got a case number and a court stamp, served the parties, and expect to be heard by court as counsel for the defendants and myself are ready to proceed." The mentality fed to the court staff is none of my business. The court staff must stop playing judge on Lieutenant Commander Sylvester Vulani Mangolele. They must process my documents just like they do for any other person. It is the court that shall apply the law, not the registrar to deny me access to the court, as is the case. The Western Cape High Court is a public place, not a personal place of Judge President Hlophe as an equal person before the law. Do not make internal problems of the Western Cape High Court to affect the public, as this matter is res publica, and all South Africans that are supporting me to have food for the past 28 months are watching this unprofessional conduct by the staff of the Western Cape Division as a place that must encourage all people to report crime, as I have done. Do not teach people to stay away from court and allow criminals to continue to run public office unlawfully. It is South Africa I carry on my shoulders, and I must die for all of you in any event as a soldier for life. I do not enjoy suffering like a slave. Stop telling people that I need permission from the Judge President to come to court. The Judge President is not the court referred to in the court order. Kindly find attached for your urgent attention and serve the Republic of South Africa in accordance with the Constitution and the law. Do not hesitate to contact me on 084-835-9161. I will be in court tomorrow morning to ensure that the judge had the file. Please tell your staff not to intimidate me or stop me from fighting for my own rights so as to satisfy others. You cannot arbitrarily or without just cause tell me that I have no right to father my children or want my property that I am deprived of by Vice Admiral Samuel Hlongwane and President Cyril Ramaphosa. They are equal persons before the law that I have called to come and account for their respective actions. Let the law take its course and stop making a fraudulently obtained court order to hinder my life and the progress of our country and its people. I do not fear to come to court, and you must stop teaching the entire republic or the universe that in South Africa, people are unlawfully and intentionally denied access to court. I have done everything right in accordance with the Constitution and the law, followed all court rules to file the matter before noon on Thursday for it to be heard on Tuesday. I did not give myself the case number and the court stamp. Stop treating me as if I am not an equal person before the law. The court is there to protect all people, not chase them away when in dire need of help. Regards. On 5 January, the plaintiff wrote a letter with file reference Flag Officer Fleet /confidential /99004046 MC, and with an address as directed by the Simonstown Magistrate Court, various streets, Cape Town, 7975. 05 January is a date on the letter. 2021. Head of Court, Judge President and Deputy Judge President, High Court of South Africa, Western Cape, Cape Town. Dear Judge President and Deputy Judge President, hearing of case number 19275/2020 in the High Court of South Africa, Western Cape Division, Cape Town on Tuesday on the 5th day of January 2021. 99004046 MC, Lieutenant Commander Sylvester Vulani Mangolele. Section 1653 of the Constitution provides that no person or organ of state may interfere with the functioning of the courts. The fraudulently obtained court order to case number 15141 of 2018, see attached here to marked CDR1, provides that I must approach the Western Cape High Court for leave to institute any legal proceedings. How do I get to court if the registrar is made to believe that I need permission from a person by the name of Judge President Hlophe? In any event, the operation of the said order is suspended pending the hearing at the Supreme Court of Appeal, and there is no way I can get to court as mandated by the court order if the staff keeps on discarding my papers and not forwarding my files to court. I have no place to stay and request the Judge President and his deputy to give direction that the matter be heard on 6 January 2021 at 1400. People must stop scaring juniors and coercing them to obstruct the administration of justice. Everyone is equal before the law and has a right to equal protection and benefit of the law. Signed by Sylvester Vulani Mangolele, Technical Support and Services Manager, Lieutenant Commander. CDR1 is the court order by the Honorable Davis J. on 14 September 2018 at Cape Town in the High Court of South Africa, Western Cape Division, Cape Town, on case number 15141 of 2018, in the matter between the Minister of Defense as the applicant and Sylvester Vulani Mangolele as the first defendant, The South African Human Rights Commission as the second respondent, South African Broadcasting Corporation as the third respondent, Cell C Propriety Limited as the fourth respondent. It reads, application for restriction on respondents' institution of vexatious legal proceedings in terms of Section 21B and C of the Vexatious Proceedings Act 3 of 1956. It was a draft order and then it became an order as soon as that signature was inserted. It is ordered that, in terms of Section 21B and C of the Vexatious Proceedings Act 3 of 1956, the Act, and for an indefinite period, no legal proceedings shall be instituted by the first respondent against any person in any court or in any inferior court without the leave of this court, or any judge thereof, or that inferior court, as the case may be, leave. Such leave shall not be granted unless the court or judge or the inferior court, as the case may be, is satisfied that the proceedings are not an abuse of the process of the court and that there is a prima facie ground for the proceedings and the first respondent has provided security for the applicant's cost. Such leave shall not be granted unless the court or judge or the inferior court, as the case may be, is satisfied that the first respondent has satisfied the judgment cost under case number 11025 of 18, case number 12095 of 18, and 13505 of 18. The cost of this application be paid by the first respondent on the scale of as between attorney and own client, by order of the court. And the stamp is as that. An advocate, Madoda Titus, as the representative of the state or the defendants, responded on 6 January 2021 at 11:25 to state, Dear Sylvester, please be advised that the defendants will not be attending at court at 1400 today. We will only attend at court when you have provided us with a notice of set down duly endorsed with the following: dated stamp of the registrar, dated stamp and signature confirming proper service at the office of the state attorney. Otherwise, without any proof of the aforesaid endorsement, we will be incurring wasted cost for my clients if we attend at court without proof that the matter will be heard at court today or any other day. I hope that you find the above in order. Kindly confirm receipt hereof per return. And on page 103, on the 9th of January 2021, a notice of set down was sent forth explicitly. The seventh respondent or defendant through the station commander of Cape Town, South African Police Service, has acknowledged the plaintiff's notice of set down, which reads, please place this matter on the roll for hearing on 9th day of January 2021 at 11:30 or as soon thereafter as counsel may be heard when leave is sought for the court to hear the matter in terms of Section 18 of the Superior Courts Act under the following circumstances. Enrolling this application in its totality from page 1 as an extremely urgent application to prevent crime, maintenance of law and order, or preservation of internal security of the Republic. Dispensing with the forms and services provided for in terms of Rule 612A. The registrar of the court is unlawfully and intentionally engaged in conduct which defeats or obstructs the course of administration of justice by not making sure that the urgent judge on duty receives the court file which was brought to court on Thursday on the 31st day of December 2020. Before noon for the matter to be heard on Tuesday on the 5th day of January 2021, and the matter was not heard. And that the court must, in terms of Section 21C of the Vexatious Proceedings Act of 1956, rescind the order issued on 14 September 2018 in case number 15141 of 2018. Attached plaintiff responding affidavit including its annexure, serves as supporting documents to this notice of set down. To the registrar, kindly set down the above matter down in accordance with the above information. Dated in Cape Town on the 8th day, January 2021. And authenticated at 10:11 on the 9th day of January 2021. The plaintiff's responding affidavit reads as follows. I, the undersigned or plaintiff, Lieutenant Commander Sylvester Vulani Mangolele, do hereby make an oath and say, I, the undersigned or the plaintiff with ID number as in the record of court and force number thereto, declare that I am a senior officer in the South African National Defence Force, duly employed in terms of Section 20 of the Defence Act number 42 of 2002 as a peace officer, and come to court with a dispute that can be resolved by the application of law decided in a fair public hearing in terms of Section 34 of the Constitution. The contents of this affidavit are within my personal knowledge and are true and factual. The national anthem is as follows. Lord bless Africa, may her glory be lifted high. Hear our prayers. Lord bless us, your children. Lord, we ask you to protect our nation, intervene, and end all conflicts. Protect us, protect our nation, protect South Africa. South Africa, from the blue of our skies, from the depths of our seas, over our everlasting mountains, where the echoing cracks resound. Sound the call to come together, and united we shall stand. Let us live and enjoy freedom in the universe, our home. The High Court of South Africa, Western Cape Division, Cape Town, is called to fulfill the Republic of South Africa to be faithful. The High Court of South Africa, Western Cape Division, Cape Town, is called to be faithful to the Republic of South Africa, uphold and protect the Constitution and the human rights entrenched in it, and administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. The dies indicae in relation to Section 18 is 2 hours notice, and the undersigned's reality is aggravating mainly because he is tortured, homeless, impecunious, without food and water. The undersigned is in full view of the challenges facing our country and its people to relax this condition and rely on Rule 612A. To the Registrar of the Western Cape Division, a duplicate file and proper internal court administration is herewith requested, following an act or omission contrary to the obligations imposed in terms of Section 1653 of the Constitution. The registrar is made to believe that the Judge President as a person must grant the plaintiff permission for leave to institute court proceedings, and not the court. This follows an incitement by Judge President Hlophe instigating, commanding, or procuring the court's registrar to commit crimes against the state and the administration of justice with the intention to unlawfully impairing, violating, threatening, or endangering the existence, independence, or security of the Republic. B. Unlawfully changing the constitutional structure of the Republic. C. Unlawfully overthrowing the government of the Republic. Or D. Unlawfully coercing the government of the Republic by violence into any action or into refraining from any action. My Lord, the action before court is for crimes against the state and the administration of justice in which the defendants are called to admit or deny a charge of high treason set out in the issues raised on page 6 at paragraph 4 of the record of court in the plaintiff's practice note, and succinctly argued on page 19 at paragraph 1.4 of the plaintiff's heads of argument. The elements of the crime are the following. A. The perpetrators must owe allegiance to the Republic. B. Conduct, in brackets, including act or omission, close brackets. C. Unlawfulness. And D. Intention. Note, my Lord, this is a charge of high treason, which applies mutatis mutandis to all defendants in the matter to be heard. Counsel appears in person before court to present an aggravating reality of the plaintiff, in which the mandament van spolie remedy is sought, following a spoliation in which the defendants took the law into their own hands and resort to self-help instead of using due legal procedure. Compliance with the provisions of Rule 4 of the Uniform Rules of Court is met, as evident on page 5 of the Notice of Motion. Therefore, all defendants are duly served and are opposing the matter as evident on page 86 or 85 to 86 of the record. If I may take His Lordship in this particular stream to page 5 of the record. Page 5 of the record. My Lord, is the stamp of the State Attorney, acknowledging receipt of the matter. And in terms of page 85 and 86 of the record, it is tried that the plaintiff has initiated the proceedings, and in defense of the subheading, service of the process initiating proceedings, and the plaintiff's appointed service address. On page 90 of the record, my lord, Rule 4AA provides that he may serve the documents as the party having initiated such proceedings, and the plaintiff could not set out any address as he lives on the streets. In order to comply with Rule 612B of the Uniform Rules and to address the subheading agency from page 91 to 92 of the record and satisfy the court to hear this matter in terms of Rule 612A. The agency of this matter is an all-encompassing national security condition explicitly set forth on page 41 at paragraph 25 of the founding affidavit. If I may take the court to all this particular thing, having the leisure of having the court to be viewing this particular video and viewing the rules that are being referred to, so that there is no argument in relation to the explicitly set forth terms in the rules of court. My lord will allow me to take leave to show the record of court in this video, page 85 of the record to page 86, where we talk about the service and processing of initiation of proceedings, page 85 and page 86. It is there. 85 and page 86, my lord, is the notice of intention to oppose. That is taken into account that they have admitted on record that they are opposing the matter as they have received the matter. That is the point that the counsel is trying to bring across for the court's consideration, my lord. And in relation to the following terms, where in which the court is led to page 90 of the proceedings and Rule 40AA. Page 90 of the proceedings, my lord, bear with me. I just only do this such that we do not have an argument in step going forward. I do not intend to mislead the court in believing any other thing other than the terms of the record of this particular court. Service of the process initiating the proceedings and the plaintiff's appointed service address, my lord. In relation to the court rules, I will take the court leave to bring the court to the court rules, rules of court, Uniform Rules of Court, Rule 41A and A4. Uniform Rules of Court. This is the Uniform Rules of Court that we all refer to, and then they are updated from time to time as the time goes on. But then mostly Rule 4 is always Rule 4, Rule 6 is always Rule 6, and Rule 9, which is the writ of arrest, is always Rule 9. Rule 43, which is matrimonial issues, is always Rule 43. Rule 8, which is Rule 8, is always Rule 8. Let me not show you how I know the rules, but let me take you to the rules of Rule 4. Service. Rule 4, service, Rule 4.1, the rule that is being referred to in this matter. Can I drag you to here, if possible? possible. Yes, yes, it's possible. You learn these things as we go. I need these uniform rules to sit next to the pages so that we don't delay in this particular regard. I have learned a new thing during the people when I'm doing this to the court, my lord. And I'm glad to learn new things every day, which is the intelligence of a brain that is learning. We are arguing Rule 4A and AA. Rule 4A, my lord. Rule 4A. Rule 4A. Where is that rule where now? Which rule 4? These are the rules that we are arguing from. Rule 41A. My apologies, my lord. Rule 41A reads services of any process of the court directed to the sheriff and subject to the provisions of paragraph AA. Any document initiating application proceedings shall be effected by the sheriff in one or other of the following manners, and it delineates the manners at which the sheriff can give or serve or effect such particular service, my lord. And in relation to the terms of Rule 41AA, where the person to be served with any document initiating application proceedings is already represented by an attorney of record, such document may be served upon such attorney by the party initiating such proceedings. My lord, without derogating from the terms, the party initiating such proceedings is oneself, counsel, and the plaintiff in the record of court this day. Going forward, my lord, in relation to cementing this reality, it is true that the plaintiff and myself as counsel initiating the proceedings or counsel appearing on behalf of the plaintiff has every lawful right to serve the documents to the parties involved, as done already. May it please the court, my lord, to observe the statutory terms of Rule 612B in the Uniform Rules, and I will take the court for the advancements already advanced in relation to non-argument going forward, and in educating the public also in relation to the statutory compliance of the rules that the plaintiff has gone through over the time, and then people based on perceptions have seen it otherwise. Rule 612B states, my lord, in every affidavit or petition filed in support of any application under paragraph A of this sub-rule, the applicant shall set forth explicitly the circumstances which he avers renders the matter urgent, and the reasons why he claims that he could not be afforded substantial redress at a hearing in due course. My lord, in applying or in adherence to those particular terms, to address the subheading agency from page 91 to page 92 of the record and satisfy the court to hear this matter in terms of Rule 612A. The agency of this matter is an all-encompassing national security condition explicitly set forth on page 41 at paragraph 25 of the founding affidavit as mandated by the rules. Page 41 of the record of court, my lord, will indicate to the court that this particular rule has been complied to accordingly, because the court will find that page 41 is included in the founding affidavit of the plaintiff. Founding affidavit and the uniform rules says there in every affidavit, it is there, or petition filed in support of any application under subparagraph, that is done in the affidavit. So the affidavit in page 41 at paragraph 25, my lord, it explicitly at paragraph 25 it explicitly sets forth the agency of this matter as an all-encompassing national condition in which, as a citizen of South Africa and a volunteer in the SANDF, the undersigned is homeless, tortured, enslaved, live without freedom, peace and safety, and every averments advanced in there have been stated. And it has been submitted that this particular matter, I just only want to bring the court to this particular attention of the founding affidavit, primarily defined in terms of the objects of the Constitution in the plaintiff's head of arguments at paragraph 19, at page 19 at paragraph 1.5. Agency was also dealt with at paragraph page 19, paragraph 1.5, my lord. The agency of this matter is the primary fact that the Constitution is the supreme law of the Republic. I am dumbfounded to be defending this particular matter, having understanding that my learned friend has read and understood the document that he is responding to, my lord. However, I'm just only alleviating the difficulty of court in relation to the argument raised by my learned friend in defense or opposition of the matter. The uniform rules of court have been observed to give the defendant sufficient time and abided by the court rules mandating filing with the registrar before noon on Thursday 31 December 2020 for the matter to be heard on Tuesday 5 January 2021 at 10:00, or as is the case. The argument is raised at page 18 at paragraph 1.3 of the heads. A situation where people in the universe, the Republic of South Africa and the entire South African National Defence Force are coerced to firmly believe that an arbitrary or without just cause, unlawful and intentional false entry in the DOD PESOL system on 8 August 2018 by Mr. Marcel de Wet, and 9 days later, on 17 August 2018, the writing of a letter by Vice Admiral M.S. Hlongwane to be delivered on Wednesday 22 August 2018 to Lieutenant Commander Sylvester Vulani Mangolele is the lawful precedence for termination of service of members in the regular force or stopping a salary of a member. My lord, the court must find this conduct inconsistent with the diligent obligation imposed in terms of the Constitution and the law in section 23(1) of the Constitution and section 59(1)(d) of the Defence Act, and declare such conduct unconstitutional, unlawful, and invalid. It cannot be considered to be fair labor that Action taken on Wednesday, 8 August 2018 to arbitrarily or without just cause stop payment of the plaintiff's salary, and a formal action to notify the plaintiff is taken 9 days later on Friday, 17 August 2018, to be delivered in the middle of the following week on 22 August 2018 as attached here to marked SVM 16. The reality of the existence of respective acts or omission on 20 June 2018, 8 August 2018, and 17 August 2018, 19 August 2020, and 2nd and December 2020 by the defendants, which inter alia changes the constitutional structure of the Republic. The national anthem is our national pride. On para 2 above, the English translation of it is employed to assist the court to comprehend the actual meaning of the words for the ease of reference or argument in relation to the last stanza. Let us live and strive for freedom in South Africa, our land. And the highest note of a proclamation issued by the state president Nelson Mandela on 20 April 1994 in terms of the provisions of section 248(1) together with section 2 of the Constitution of the Republic of South Africa, 1993, Act 200 of 1993, stated that the Republic of South Africa would have 2 national anthems. They were Nkosi Sikelel' iAfrika and the Call of South Africa, Die Stem van Suid-Afrika. In terms of Section 4 of the Constitution of South Africa, 1996, Act 108 of 1996, and following a proclamation in the Government Gazette number 18341 dated 10 October 1997. A shortened combined version of Nkosi Sikelel' iAfrika and the Call of South Africa is now the national anthem of South Africa, and it is the only neo-modal national anthem in the world. By virtue of being the only one that starts in one key and finishes in another. The lyrics employed the 5 most populous of South Africa's 11 official languages. isiXhosa, the first stanza, the first 2 lines. isiZulu, first stanza, last 2 lines. Sesotho, second stanza. Afrikaans, the 3rd stanza. And English, final stanza. And the last stanza must now change its terms to let us live and enjoy freedom in the universe, our home, and free our democratic nation from slavery to live and struggle, endeavor, strive, or attempt for freedom in South Africa, our land, their land. In relation to each prayer advanced in the notice of motion, the court must enroll this application as an urgent application, fulfill the obligations imposed in terms of Section 21 of the Constitution, fulfill the obligations imposed in terms of Section 2 of the Constitution. The court must fulfill the obligations imposed in terms of Section 10 of the Constitution. The court must fulfill the obligation imposed in terms of Section 11 of the Constitution. The court must fulfill the obligation imposed in terms of Section 12 of the Constitution. The court must fulfill the obligations imposed in terms of Section 13 of the Constitution. The court must fulfill the obligation imposed in terms of the preamble of the Constitution. The court must fulfill the obligation imposed in terms of Section 4 of the Constitution. The court must fulfill the obligation imposed in terms of Section 2A of the Defense Act, read with Section 4 of the Prevention of Combating and Torture of Persons Act. The court must fulfill the obligations imposed in terms of Section 89 of the Constitution. The court must fulfill the obligations imposed by the supremacy of the Constitution and the rule of law. The court must fulfill the obligation imposed in terms of Section 54(3)(a) of the Defense Act. The court must fulfill the obligation imposed by the executive function of the second defendant. The court must fulfill the obligation imposed in terms of Section 23(1) of the Constitution. The court must fulfill the obligation imposed in terms of Section 205(3) of the Constitution. The court must fulfill the obligation imposed in terms of Section 25 and 26 of the Constitution. Fulfill the obligation imposed in terms of Section 23(1) of the Constitution. The court must fulfill the obligation imposed in terms of Section 25 of the Constitution. The court must fulfill the obligation imposed in terms of Section 33 of the Constitution. The court must fulfill the obligation imposed in terms of Section 8 of the Constitution, and the court must fulfill the obligation imposed in terms of Section 21C of the Vexatious Proceedings Act. And I will take the court to Section 21C of the Vexatious Proceedings Act, just for the court to see for itself where is reference drawn in this regard. As it pleases the court, my lord, Vexatious Proceedings Act in terms of Section 21C where I will just a moment, my lord. I will come to this. Vexatious Proceedings Act. My apologies, my lord, I'm just doing this for ease of reference and non-repeating of activities. The Vexatious Proceedings Act, my lord, in terms of Section 21C. Here's the Vexatious Proceedings Act, number 3 of 1956, Section 2(1), powers of court to impose restriction on the institution of vexatious legal proceedings. The court has the power to 21C make an order under paragraph A or B may be issued for an indefinite period or for such a period as the court may determine, and the court may at any time, on good cause shown, rescind or vary any order so given. The rescission, my lord, is in terms of Section 21C, where this is the time where the court must rescind or vary this particular fraudulently obtained court order. I will bring the court back to Section 8 of the Constitution, and I do this with diligence, my lord, in view of persons having to see all this because they don't know. I am educating the Republic of South Africa in relation in this regard. And in educating the Republic of South Africa in this regard is such that, one must be diligent enough and patient enough with the future, so that also they can be able to fly too in understanding. I will beg the court's indulgence to the statutory terms of Section 8 of the Constitution. It is not with disrespect to the court's library. It is with respect to educating the Republic of South Africa for generations to come. I know that we are taught that we must not lecture the court with the law, but this is a special case wherein the public interest is aroused. My Lord, Section 8 of the Constitution mandates the court, and I will take it to Section 8.3. I say this because I know it as the court knows it, but the public does not know it, so that they can see what do I mean. When applying a provision of the Bill of Rights to a natural or juristic person in terms of subsection 2, subsection 2 says, a provision of the Bill of Rights binds a natural or juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. You see, a provision can be children, for example. As a natural person and or as a juristic person, you have an obligation to children, and everybody has got an obligation to children because children are stated as of paramount importance in every matter concerning them, such as this particular matter. See, and coming back to this, a court, in order to give effect to a right in the bill, must apply or, if necessary, develop the common law to the extent that legislation does not give effect to that right. If legislation does not give effect to the right that I must be with my children, the court must make that right happen, because the right of having to be with one's children is an inalienable right. May develop rules of the common law to limit the right, provided that the limitation is in accordance with Section 36(1). And the limitation of rights, when you limit the rights, many people don't want to read this thing, and then it's very important for them to read and understand the limitation of rights. This is a table of non-derogable rights, is Section 37. Limitation of rights is Section 36. It says, the rights in the Bill of Rights may be limited only in terms of law general application. We go back to application, go back to that particular Section 8 that we are talking about, to the extent that the limitation is reasonable. My Lord, I put to this court that it is unreasonable for the plaintiff to be without his children. It is unreasonable for the plaintiff to be without his salary. It is unreasonable for the children of the plaintiff to be without the plaintiff as their father. And justifiable in an open and democratic society based on human dignity, equality, freedom, taking into account all relevant factors, including the nature of the right, parental responsibilities, and natural rights that are limited to the age of 18. You cannot say to me, my child will grow up and he will come to me after he has grown up, and he will no longer be a child after 18. What is being stolen from the plaintiff, my lord, is precious, is of paramount as regarded by the Constitution. The importance and the purpose of the limitation, the nature and the extent of the limitation, the relation between the limitation and its purpose. What is the purpose of limiting my access to my children by depriving me of my salary in service and defense of my country and its people? What is that particular purpose, your lordship? And this is done by the people who says we pledge to serve and defend the country and its people in accordance with the Constitution and the law, as chapter 11 persons. Less restrictive means to achieve the purpose. With me, it's a permanent means to achieve the purpose. Except as provided in subsection 1 in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. My lord, the application of rights in section 8 is within the Bill of Rights. Cannot be limited. The court must apply the law at all times. Coming back, my lord, the court must fulfill the obligations imposed in terms of section 33 of the Constitution. The Constitution in section 33 imposes an obligation that everyone has a right to administrative action that is lawful, reasonable, and procedurally fair, my lord. Everyone whose right has been adversely affected by administrative action has the right to be given written reasons, which the plaintiff has not been given to this particular date. My lord, national legislation must be enacted to give effect to these rights. And my lord, I put it to you that national legislation has been enacted to give effect to these particular rights that one is currently exercising, and must provide for the review of administrative action by a court, or where appropriate, an independent and impartial tribunal, impose a duty on the state to give effect to the right in subsection 1 and 2 and promote efficient administration. My lord, the people are viewing this particular reality, and in viewing this particular reality is such that I have been taking this reality, as you can see here. This is what the court must do, and this is what section 33 of the Constitution says, as I have been explaining to you. I just do not want you to be glued to the Bill of Rights and this particular notice of motion, because you are going to read it anyway as the court, and fulfill the obligations imposed in terms of section 25. In terms of section 25, section 25 imposes an obligation that everyone may not be deprived arbitrarily or without just cause of property, if I remember correctly. No one may be deprived of property except in terms of the law of general application, and no law may permit arbitrary deprivation of property. It doesn't matter, even when you have applied the law by general application, it is clear that no law may permit arbitrary deprivation of property. The word end, it separates. I remember when I was talking with some of my old friends in conversation, my lord, and then I bring it to this particular matter in relevance and observance of the statutory terms of Section 210 of the Criminal Procedure Act, when I bring the court to the observance of end, the term end, and that particular term comes after a comma. This statement, it's a statement on its own. I'm educating this to the public, my lord, not to the court per se. I respect the function of court and its library. Comma is very important in law, and the term end is very important in law. As I was saying, people, you can look at it is one conversation that I was drawing relevance to. You have Section 25(1) is like this, if I may explain it to be proficient. Section 25(1) is like this. My friend would say they are like buttocks. They do everything together, and they sit together and they walk together. It's buttocks, and the only time when they separate is when something comes out, and that particular something is an end in this particular regard that separates buttocks. It does not mean that buttocks are not in one body, as it would be said in terms of Section 25(1) as a body on its own. Section 25(1), it's a body on its own, and then it has a full stop. That's a body. I'm explaining this concept such that you understand the relevant meaning of grammar and its application in law and its actual meaning. So when you have this particular body which is encompassing the buttocks, in it, these buttocks do separate where they are independent from one another, and the end part comes into play. And you have to entertain the end and then take into consideration the full function of the buttocks as and when they perform their respective functions. So, in view of these particular terms, I will not repeat or recite Section 25, but then the whole thing is all applicable terms of Section 25 is what I mean for the record of court, my lord. And in this particular regard, same applies to Section 23(1), same applies to all the fulfill the obligations. Coming back to the record of court, my lord, on page 110, in the spirit of Ubuntu to be employed when deciding the matter. Patupili is also about moving the public service from a rules-bound approach that hinders the delivery of services to an approach that encourages innovation and is result-driven. My lord, this is written on page 110. In other words, instead of looking for reasons why government cannot do something, they have to find better ways to deliver what people need. This belief set is summarized by the slogan, "We belong, we care, we serve." The overarching frameworks is as follows. We belong, we are part of the public service and should work together and respect fellow colleagues. In simple terms, we care, caring for the public we serve, our customers. We serve. All citizens will get good service from public servants. In closing that argument, my Lord, is that it's like, for example, when one approaches the office of the Chief of the South African National Defence Force, which is duty-bound to serve each and every person in the Republic of South Africa when it requires services from. These are the principles that must be employed. This Honourable Court is a public servant that is independent and subject only to the Constitution and the law, which it must apply impartially and without fear, favor, or prejudice, where no person or organ of state may interfere with its functioning. Having absolute trust that the court has read the papers filed on record to this end, the plaintiff applies to this Honourable Court to have his property returned to him after the defendants unlawfully and intentionally dispossessed his property. This matter satisfies the two elements held in the case of Yeko and Kana in 1973, open brackets 4, close bracket, SA 735, that an application for a spoliation remedy must satisfy the court that he was in possession or had a quasi-possession of the property, and that the respondents deprived him of the possession forcibly or wrongfully against his consent. These requirements constitute both a requirement and defense for and against the remedy of mandament van spoil, my Lord. It is submitted that the plaintiff dispossessed the defendants of nothing, but instead the plaintiff performed his imposed duties with diligence and absolute zeal, as is the case, in defense and protection of the country and its people, to report apartheid, criminal activity, corruption and misconduct. My Lord, when the Constitution mandates that the court must entirely protect the right to human dignity and the right to life of the plaintiff, that is what the court shall do in any event. Today, the court is faced with a reality in which all courts since 20 June 2018 has failed to entirely protect the human dignity and the right to life of the plaintiff to sustain the reality that he is placed on the streets. His Lordship would take kindness into drawing his attention to the provisions of Section 37 in relation to the statutory terms of Section 37(5) of the Constitution, where no Act of Parliament that authorizes a declaration of state of emergency, and no legislation enacted or other action taken in consequences of a declaration may permit or authorize indemnifying the state or any person in respect of any unlawful act or any derogation from this section. And I submit to this court, my Lord, that this particular section is the backbone of the Constitution. This is the only section in the Constitution that explicitly sets forth that no act of Parliament that authorizes a declaration of a state of emergency and no legislation enacted or any other action taken in consequence of a declaration may permit or authorize any derogation from this section, or any derogation from a section mentioned in column 1 of the table of non-derogable rights to the extent indicated opposite that section in column 3 of the table. Column 1 of the table of non-derogable rights, section 9 cannot be compromised equality, and the extent at which equality cannot be compromised is with respect to unfair discrimination solely on the grounds of race, color, ethnic or social origin, sex, religion, or language. And in relation to any derogation that cannot be taken in terms of section 10 is human dignity, which the extent to which the right is protected is entirely. Section 11 is life, which is also entirely protected by the table of non-derogable rights, my Lord. My Lord, that simply means that the court cannot find any excuse to say, I am not protecting the right of any person of human dignity. To put further impetus, my Lord, to this, it then becomes apparent that the constitutional structure of the Republic is unlawfully and intentionally changed by senior government officials owing allegiance to the Republic of South Africa, engaged in conduct defeating or obstructing the administration of justice with the intention of violating, threatening, or endangering the existence, independence, or security of the Republic, to subject the plaintiff into a state of homelessness, torture, slavery, cruel, inhumane, or degrading treatment or punishment, arbitrary loss of past and future income for the past 36 months, my Lord, and arbitrary deprivation of property. In the case of Mangolele, EDMS BPK versus Municipalent van Ontavi in 1989, open bracket 1, close bracket all, SA 416A. It was held that since an incorporeal right cannot be possessed in an ordinary sense of the word, the plaintiff being king of the universe as an example, the possession is represented by the actual exercise of the right. Therefore, refusal to allow a person to exercise the right will amount to dispossession of the right. Possession need not have been exclusive possession. A spoliation claim will lie at the suit of a person who holds jointly with others. My Lord, Zaid Raad al-Hussein said, the United Nations High Commissioner for Human Rights introduced the Universal Declaration of Human Rights, hereinafter referred to as the UDHR, and said, in perhaps the most resonant and beautiful words of any international agreement, all human beings are born free and equal in dignity and rights. The commitments made by all states in the Universal Declaration of Human Rights are in themselves a mighty achievement, discrediting the tyranny, discrimination, and contempt for human beings that have marked human history. The Universal Declaration promises to all the economic, social, political, cultural, and civic rights that underpin a life free from want and fear. They are not a reward for good behavior. They are not country-specific or particular to a certain area or social group. They are the inalienable entitlements of all people at all times and in all places. People of every color, from every race and ethnic group, whether or not they are disabled citizens or migrants, no matter their sex, their class, their caste, their creed, their age or sexual orientation. Human rights abuse did not end when the Universal Declaration was adopted. But since then, countless people have gained greater freedom. Violations have been prevented, independence and autonomy have been attained. Many people, though not all, have been able to secure freedom from torture, unjustified imprisonment, summary execution, enforced disappearance, persecution, and unjust discrimination, as well as fair access to education, economic opportunities, and adequate resources and health care. They have obtained justice for wrongs and national and international protection for their rights through the strong architecture of the international human rights legal system. The power of the Universal Declaration is the power of ideas to change the world. It inspires us to continue working to ensure that all people can gain freedom, equality, and dignity. One vital aspect of this task is to empower people to demand what should be guaranteed: their human rights. This booklet constitutes a modest but significant contribution to that work. And the booklet referred to, my Lord, is the Universal Declaration of Human Rights. The plaintiff and the defendants jointly control his right to life entrusted to the nation and the state, as alluded to in the first paragraph of page 15 of the heads of arguments. In Solar Mounting Solution Pty Ltd versus Angela Africa Pty Ltd, unreported case number 3717/2014, 5-9 of 2014, right acting justice, it was held that even though the applicant may not have had actual possession of the property complained of, it had a right of access to points of the site. Thus, there are instances in which use of enjoyment of a thing has an element of sufficient control to be said that the dispossession person was in possession, which qualifies him or her to be protected through the application of mandament vanspole remedy. Since Section 12(1)(d) of the Constitution provides that everyone has a right to freedom and security of the person, which includes the right not to be tortured in any way, and mindful that the Republic of South Africa has a shameful history of gross human rights abuses, including the torture of many of its citizens and inhabitants, has, since 1994, became an integral and accepted member of the community of nations. It is committed to preventing and combating of torture of persons, amongst others, by providing persons who carry out acts of torture to justice as required by international law, is committed to carrying out its obligations in terms of the United Nations Conventions Against Torture and other cruel, inhumane, degrading treatment or punishment. And since each state party to the United Nations Conventions Against Torture and other cruel, inhumane, or degrading treatment or punishment must take effect, legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction. Section 4.3 of Act number 13 of 2013 provides that despite any other law to the contrary, including customary international law, the fact that an accused person is or was a head of state or government, a member of a government or parliament, an elected representative or a government official, or was under a legal obligation to obey a manifestly unlawful order of government or superior, is neither a defense to a charge of committing an offense referred to in this section, nor a ground for any possible reduction of sentence once that person has been convicted of such an offense of torture. My Lord, it is submitted that one of the factors to be taken into account by the court when considering the presence of aggravating circumstances of the plaintiff and without excluding other relevant factors is any discrimination against the victim or the plaintiff. In this regard, as contemplated in Section 5A of the Prevention of Combating and Torture of Persons Act, it is tried that everyone is equal before the law, and that includes the incumbent President of the Republic of South Africa. In matters concerning the dispossession of right, the requirement of dispossession is satisfied by showing that a previously exercised utility has been disturbed. In that order, the emphasis of physical possession involves rather strained reasoning. For example, when a tenant is locked out, it is regarded as dispossession because his or her access rights have been disturbed. As is the case with the plaintiff in this matter, it is submitted to the Honorable Court that the dispossession of a right will always be manifested by the deprivation of an extremely demonstrable incident, such as the use arising from or being integral to the right in question. My Lord, in the case of Tigon Ltd versus Bedstate Investment Property Ltd, 2001, open brackets 4, close brackets 634, open brackets November, close brackets, clearly demonstrates this point. In casu, the court examined the juristic nature of the rights of a holder of shares in a company. This was in order to determine whether the removal of its name from the shares register constituted disposition for the purpose of being able to obtain relief in terms of the mandament van Spoli. The court held that mandament van Spoli was available. In such an instance, because the act of removing the name constituted dispossession for the purpose of spoliation remedy. My Lord, having regard of the imposed obligation that no law may permit arbitrary deprivation of property, the same shall be arrived at by this court following an act of placing the plaintiff's belongings on the streets, on an unlawful instruction of the second defendant, and the lawfulness of the letter dated 17 August 2018 in relation to number 4 Cable Hill Road, Simonstown 7975. The court must limit the retrospective effects and make an interlocutory order to restore the plaintiff's security of tenure to land and property of number 4 Cable Hill Road, Simonstown 7975. In Fredericks and another versus Stellenbosch Divisional Council 1977, open brackets 3, close brackets SA 113, open brackets C, close brackets. Despite the fact that the dwellings had been destroyed together with the building material and such a situation posing a perfect defense of impossibility of restoration, the court ordered restoration. The court relied on Zimner versus Miller of 1956, open brackets 3, close bracket, SA 8, open brackets T, close bracket, and Jones versus Claremont Municipality of 1908, open brackets 25, close brackets, SC 651, to come to a conclusion that the remedy could be used in instances where restoration required something to be done in addition to repossession of the subject of dispute. The court in Fredericks went to the extent of ordering that if the original sheets of congregated iron could not be found, the respondent should use sheets of similar size and quality as the original ones. My Lord, these facts are presented to guard against the defendant stating to the court that the plaintiff must be bought a new car instead of restoring the vehicle which was unlawfully and intentionally dispossessed of by violence, when the second defendant, as head of the National Executive, had authorized the employment of the Defense Force in cooperation with the police service to unlawfully and intentionally use violence to take the property from the plaintiff, or threats of violence to induce the plaintiff to submit to the taking of the property on 11 September 2018 inside the Community Service Center of Sunnyside Police Station. On 14 September 2018, my Lord, the court arbitrarily or without just cause issued a court order which makes people in the universe, especially the court staff of the Western Cape Division, to unlawfully and intentionally engage in conduct which defeats or obstructs the cause or administration of justice as a result of hearsay seemingly incited by the incumbent Judge President Tlhophe, that the undersigned has no right to enter court, while Article 6 of the Universal Declaration of Human Rights and Section 9 read with Section 34 of the Constitution of the Republic of South Africa provides otherwise. This constitutes violating the dignity, repute, or authority of a judicial body or a judicial officer in his judicial capacity in relation to the undersigned's dependents. May it please the court, my lord, for it to be submitted that on 14 September the undersigned was not in the Western Cape, and the court did not comply with the statutory obligations imposed in terms of Section 21B of the Vexatious Proceedings Act 3 of 1956, hereinafter referred to as the Act, to hear or give the undersigned an opportunity of being heard before ordering that legal proceedings shall be instituted by the undersigned against any person or any court or any inferior court without the leave of this court. And if I may add, in error of grammar there, my lord, no legal proceedings shall be instituted by the undersigned against any person or in any court or any inferior of the court, or any inferior court without the leave of the court, or any judge thereof, or that inferior court, as the case may be, and that such leave shall not be granted unless the court or judge or the leave or the inferior court, as the case may be, is satisfied that the proceedings are not an abuse of the process of court, and that there is a prima facie ground for the proceedings. Therefore, the court order cannot be in terms of Section 21B and C of the Act, and was unlawfully and intentionally issued. Take cognizance. The Vexatious Proceedings Act, to cement this particular part, my lord, provides that after hearing that person or giving him an opportunity of being heard, after hearing that person or giving him an opportunity of being heard, may it be ordered that no legal proceedings shall be instituted. This is the Vexatious Proceedings Act. It says that a court, whether against the same person, the court may, after hearing that person or giving him an opportunity of being heard, that is what the law says, that is what must be followed, that is what was not followed on 14 September. However, the misrepresentation comes as if such was followed. I take liberty, my Lord, to continue and say, in an event that the court is in doubt of the undersigned's presence, and without causing undue strain in volumes of paperwork, the record of the Gauteng division in Pretoria shall prove that the undersigned was on record at various times on Thursday the 6th, Friday the 7th, Saturday the 8th, to sleep outside the glass door of the office of the Commander-in-Chief in full military uniform, as can be seen attached here to marked SVM 17 on Sunday the 9th and Monday 10th September, only to be robbed of 2,500 his car keys, unlawfully stripped of his military rank and uniform inside the Community Service Center of Sunnyside Police Station on 11 September 2018, and later that day, the military police unlawfully and grossly violated the undersigned's privacy to search his maternal home without a search warrant and took all military uniform of the undersigned while he was left at the police station, opening a case of robbery which has never been prosecuted to this day, and appeared in again in the Pretoria High Court on 12 September at or about 17:30 to appear at 0600 Thursday morning 13 September, and later that day at or about 1800. All this effort leading to ensuring that the undersigned never gets to Cape Town and assist the court fulfill the obligation imposed by the supremacy of the Constitution and the rule of law to have persons equal before the law to account, as it is the duty of all parties to assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts as mandated in terms of Section 1654 of the Constitution, my Lord. Having regard of the irreparable harm suffered by the undersigned, the actual statutory terms of Section 21B and C of the as contemplated in the court order on page 100 to 101 of the record, the primary fact that the undersigned was never heard or granted an opportunity of being heard, the court must without fear, favor, prejudice declare the court order unconstitutional, unlawful, and invalid. The undersigned is subject to impossibility as a result of the court staff being led to believe that permission from Judge President is required and not that of the court. Therefore, the undersigned is denied access to court as a result of the belief that changes the constitutional structure of the Republic in relation to the obligations imposed in terms of Section 165(3) of the Constitution, which provides that no person or organ of state may interfere with the functioning of courts. The center of gravity of this matter is case number 12096 of 2018, to be heard in Solidium by a full bench on 14 September 2018, as directed by Judge President by the Judge President of the Western Cape Division, and inter alia includes the incumbent Chief of the South African National Defence Force General Solishoke and Chief of the Navy Vice Admiral Samuel Hlongwane as unwilling but competent and compellable witnesses. It is submitted that every effort was made that the undersigned does not appear in court, including robbing him of 2,500 that he intended to use for travel and his car keys on 11 September 2018 after the Pretoria High Court denied him leave to travel at state expense. It is right that the undersigned's right to life is entrusted to the nation and the state. My Lord, if I may take you to SVM (17), as alluded to, that is the picture of the plaintiff at the Union Buildings wearing uniform with the intention to pay marks of respect to the Commander-in-Chief when reporting the reality of the record of court in Gauteng Division in Pretoria. That reality is a constitutional obligation imposed on the plaintiff. And this is the response that he got from the Commander-in-Chief on the 11th of September 2018, wherein it's an email from Roshin Sai, and it's sent to Shonisani Mdau, and then the subject there is Memorandum from Lieutenant Commander Sylvester Vulani Mangolele, and then it says, thanks, kindly note that this is a court matter and we cannot interfere. That is what the Commander-in-Chief has said. So this is indeed true, a court matter, my Lord. This was after the original message was from Shonisani Modau to many others, including, if I may, for the record of this particular proceedings, my Lord, to be specific to the actual cause and bring this matter to the attention of the court such that it sees the people that are involved in it. Technology is defeating my technology, which is currently responding slow, and I beg the leave of the court to just, while waiting for this, have a sip of water. Water is finished during the court session. My Lord, if I may, in a good read of this particular matter, if it may respond, I just only want to put on record of court the names of these particular people. Come on. Oh. Technology is failing me. Be it as it may, we are here through the grace of the Lord. God is good all the time. If I may, as the court pleases, my Lord, take His Lordship to the actual original picture that is sent on this, and then make it bigger such that the court and the public can have timely, accurate and accessible information. Just only to show the public, my lord, that in order to achieve the making of this particular live streaming, it's not a child's play. There's a hard work that goes behind. This is the picture of the plaintiff in color, and this is the response from Rushin Sai. And if I may make it bigger, Rushin Sai on 10 September 2018 at 0140 p.m. and then it was sent to Shonisani Mudau, and Shonisani Mudau gave me this on 11 September. He did not tell me, because what I have said on the 10th, I have slept outside also on the 10th, as I was adamant to address the Commander-in-Chief as a subordinate who must be respected, supported and treated fairly as mandated by the Code of Conduct for Uniform Members of the South African National Defence Force. So there, Shonisani Modau sent this at noon, 12:27 on 10 September. And then it was responded to an hour later. I believe at this particular time the president was attending Lampisa conference in Cape Town while I was in Pretoria, and then I had to be in Cape Town at that particular time as a scholar, a master scholar in the program run by Dr. Joa of the Cape Peninsula University of Technology, who is my mentor and suffering strain as a result of the inaction of this matter. Shonisani Mudau sent this to Robert Ngobeni, Hlongwane, Goodman Makamu, Jan Manaiwa, Makosini Makubele, Poshia Mtombeni, Abraham Motwa, and then CC'd Roshin Sain, Isaac Porto, Mandla Feni, Calvin Humbles, Vincent Ngobodwane, I'm sorry for that, Ngobondwane, Tabiso Moloi, Tabo Makaza, Wendy Butelezi, Amanda Bua, Nelisiwe Mvubu, Kiamogetswe Seleke, SAPS House, and the subject was memorandum from Lieutenant Commander Sylvester Vulani Mangolele, SA from the SA Navy. Says, good day, colleagues. Attached, please find the memorandum of Lieutenant Commander Sylvester Vulani Mangolele from South African Navy, who slept outside the glass door yesterday meaning the 9th of September, which was the Sunday, when one arrived at the office of the Commander-in-Chief to see the President. However, he said he will sleep here again today if not assisted with transport fares back home. Hope you find the above in order. And then regards the Presidency, Internal Security, Principal Security Officer, Senior Safety Officer, and then their respective cell phone numbers. And to tell you the truth, that cell phone number, when I call it, it is now blocked for my cell phone. And Shonisani at Presidency, and then this particular address also blocks my email address from sending it any email. Without any further ado, my lord, these are the attachments that I wanted to show to his lordship in relation to this particular matter. The thing is, I want to leave no room of doubt in His Lordship's mind in relation to the averments advanced, and I beg the indulgence of the court in that regard. My Lord, following the above averments, it is submitted and argued that the undersigned did his part to petition the Supreme Court of Appeals, as can be seen attached hereto, marked SVM 18. And as is the case in this instant, and it is evident that the undersigned's dignity or reputation is discussed with absolute malice and no intention to uphold the law in relation to the undersigned. It is not that the undersigned is not doing anything. It is just that he is arbitrarily or without just cause being prevented or denied service unlawfully and intentionally. In no event did the Supreme Court of Appeal contact the undersigned to come to court, which is the same thing that is happening from the court trying to send the undersigned by all means to Bloemfontein and subjecting him to impossibility in suppression of the truth. The court must understand it to be true that there is a group of corrupt judicial officers and is required to only act as mandated by the Judicial Code of Conduct. The undersigned is extremely tired of going up and down as if he is a novice in terms of subsection 18.5 of the Superior Courts Act. A decision becomes the subject of an application for leave to appeal or of an appeal as soon as an application for leave to appeal or a notice of appeal is lodged with the registrar in terms of the rules. My Lord, it is submitted that the operation of law is unlawfully and intentionally defeated or obstructed as a result of theft by false pretense, whereby the state unlawfully or intentionally obtains movable corporeal property belonging to the undersigned with the consent of the court of law, such consent being given as a result of a misrepresentation by the court, which is Davis J, and appropriate, as is the case with all property, salary, and pension of the undersigned, resulting in the unlawful, intentional, and serious violation of the undersigned's dignity or privacy. In simple terms, such is crimen injuria. It is further submitted that the one of many objectives achieved by fraudulently obtained order is to weaken the independence, impartiality, dignity, accessibility, and effectiveness of the courts, and introduces a paradigm shift that the South African High Court must deny any person his or her parental responsibilities and rights so as to perpetually allow or sustain torture, slavery, apartheid, criminal activity, corruption, misconduct, cruel, inhumane, or degrading treatment or punishment in relation to the undersigned. My Lord, the office of the Chief of the South African Navy is not the only office that holds true that number 4 Cable Hill Road, Simonstown 7975 is the lawful address of the letter is the lawful address in terms of the letter dated 17 August 2018, attached here to marked SVM 3 on page 61 of the record. The State Attorney confirms same on the notice of intention to tax bill of cost issued in terms of case number 15141 of 2018 on 3 December 2018, as can be confirmed attached here to marked SVM 19 before. Therefore, the court has no any other lawful reason not to grant the interlocutory order sought and solve the issue of homelessness in this matter. As the court may see, my lord, on the word format of this. This is the petition to the judiciary, to the Supreme Court of Appeals, and then which was sent on 2024 February, and then here also, and then this is the response by Charmaine van der Merwe on February 5th, 2020, when he tells you to go to Paul Maibro. So there has been communication with the Supreme Court of Appeal in relation to this particular application, and you can see the SCA application which was lodged at that particular point in time. So the execution and operation of the vexatious litigant order is suspended pending the hearing of this matter. Just to bring the Honorable Court to the actual alluded text bill in relation to address of number 4 Cable Hill Road, Simonstown, where the first Mr. S.V. Mangolele, first respondent for Cable Hill Road, Simonstown, is the address that is being displayed in this particular matter. And then having them being displayed like that, I am caused to believe this document as a lawful document coming to Mangolele in regards of this particular case number. So, interlocutorily so, the court will be satisfied that this particular document was signed on the 3rd day of December 2018. My lord, I would beg the indulgence of the court after taking the court through this particular notice of set down, which was not heard in accordance with its terms. However, the terms are important. And when the undersigned, amongst many of his approaches to the court, Judge President Hlophe plays goalkeeper as attached here to marked SVM 20, which means the undersigned is designed not to get his personal belongings at all. What is at play is a syndicate changing the constitutional structure of the Republic by interfering with the functioning of courts. It is submitted that no full bench has been granted by Judge President, who knows very well the provisions of Section 24A of the Supreme Court Act, that no appeal shall lie against the judgment or order of the court of a provincial or local division in any civil proceedings, or against any judgment or order of that court given on appeal to it, except in the case of a judgment or order given by any civil proceedings by the full court of such a division on appeal to it in terms of subsection 3, with the special leave of the appellant division. In simple terms, my lord, for the public's sake, for them to understand this, before the matter of the Vexatious Proceedings Act may be heard by the Supreme Court of Appeal in terms of the obligations imposed in terms of Section 24A of the Supreme Court's Act is that the Western Cape Division must hear this particular matter as a division, which requires a full bench. It is therefore clear that Judge President Hlophe suffers from incapacity, is grossly incompetent, or is guilty of misconduct as a person owing allegiance to the Republic of South Africa who unlawfully engages in conduct with the intention of unlawfully impairing, violating, threatening, or endangering the existence, independence, or security of the Republic, unlawfully changing the constitutional structure of the Republic, unlawfully overthrowing the government of the Republic, or unlawfully coercing government of the Republic by violence into any action or into refraining from any action. See Mayekiso 1988 4 SA 738 open brackets W close brackets 742 tag 750. If I may take His Lordship to SVM 20 for the record of court. SVM 20 is a letter from Judge Hlophe dated 16 May 2019, where it says, "Dear Mr. Mangolele, I refer to your communication or application for leave to sue the President of the Republic of South Africa and the Commander-in-Chief. Leave to sue is accordingly denied. Judge President Hlophe." So, this is done having regard of this provision. Constitution in terms of provision 1653. I want to explain to you this nicely so that you get educated in the applicable terms of the law. Courts and administration of justice, judicial authority. No person or organ of state may interfere with the functioning of the courts. No person. Hlophe is a person. Justice Hlophe is a person. Organ of state, Judge President is an organ of state, or the office of the Judge President is an organ of state. And in this regard, you have just seen the opposite of the law, that is changing the constitutional structure. In simple terms, what had happened for Judge Hlophe to come to this particular conclusion, he looked at the notice of motion and then arbitrarily or without just cause decided to deny this matter. And in denying this particular matter, it sustained the criminal activity, corruption, and misconduct or apartheid, causing the irreparable harm to the plaintiff, my lord. If I may bring His Lordship back to the attention of this particular matter, and by Judge President Hlophe calling or referring to a juristic person such as the plaintiff as a mister is inconsistent with the provisions of the Defense Act in terms of Section 54. Because the Defense Act in terms of Section 54 provides that only the President may cancel the permanent commission, and such permanent commissioned officers in the Defense Force, that is Section 54, dealing with it. Section 54.3 tells you that only the president may cancel a permanent commission, but such a commission may not be cancelled without the holder thereof being notified in writing of any complaint or charge made against him or her, and of any action proposed to be taken in respect thereof, nor without him or her being called upon to show cause in relation thereto. So, commission means rank. Cannot be calling me a Mr. my Lord. Just I cannot be calling you as a judge a Mr. my Lord. That's why I refer to you as my Lord. That is constitutionally correct and constitutionally so. The plaintiff must be referred to in accordance with his rank. Rank in the military as a commissioned officer shows that you are representing the president at any given time. To have a court registrar prepared to have a physical fight with a senior officer in the South African National Defence Force, or any natural or juristic person in the Republic of South Africa, instead of fulfilling the obligations imposed by the basic values and principles governing the public administration in terms of Section 1951 of the Constitution, constitute coercing by violence the government of the Republic into inaction to grant the undersigned a fair trial, or into action of denying the undersigned access to court and refraining him to equal protection and benefit of the law. My Lord, the court registrar or the judge president of any court owes allegiance to the Republic and have committed high treason. The Jagger versus Attorney General of Natal in 1907, when you look at 1904 up to 1907, A11 ER 1008, open brackets PC. In Newman, 1949, 3 SA 1238, open bracket SPCT, close. In Mange of 1980, 4 SA 613 A 619F. In Tsotsobe of 1983, 1 SA 856 A 866 Tech 867. In Mangolele, 1984, 2 SA 314, open brackets N close brackets 323 E. In Gaba of 1985, 4 SA 734 A. In Pasteur, unreported WLD 1505 186, discussed by Sneyman 1988 in SACJ 1FF. The court must direct a return date in which Judge President Hlophe and others employed in the Western Cape Division Registry will be given a fair opportunity to defend themselves following due court process, as it shall be unethical to allow perpetrators of misconduct, abuse of authority, corruption, obstruction of justice to continue to work in government departments, while there are many fellow South Africans who are without employment and suitable qualifications, yearning to provide a high standard of ethical service to the country and its people. My Lord, Section 21C of the Vexatious Proceedings Act 3 of 1956 provides that an order under paragraph A, as alluded to, has already been canvassed in this particular record. The Superior Courts Act in terms of Section 9(1) mandates that the courts be open to the public every business day and allows the court as may be and allows the court to rescind or vary this order on any Sunday, Saturday, or public holiday as may be required from time to time. Any person can only wonder why each competent court has constantly failed to uphold this obligation, unless it is indeed true that something is very wrong in the court system as a critical capability of state and the upper guardian of the children's rights when taking into account Fox Crawford J in V versus V in 1998. Were deliberated upon in the plaintiff's set of arguments on page 17 of the record in relation to paramount importance of the upper guardian as mandated. Without a home and the continued denial of access to court so as to protect the incumbent President of the Republic and the Chief of the South African Navy from accountability as equal persons before the law, the undersigned does not meet the first requirement of care and contact of his two children who suffer irreparable harm without their father in their lives. All their birthdays or the special days past shall never be repaired by any amount of money, as children constitutes a vulnerable group who are entitled to special care and assistance, but because the protection of children's rights leads to a corresponding improvement in the lives of others sections of the community, because it is neither desirable nor possible to protect children's rights in isolation from their families and communities. The undersigned trust that any parent shall concede that the children must thus be protected and assisted to facilitate the full and harmonious development of their personalities and to grow up in a family environment and in an atmosphere of happiness, love, and understanding. The reality of this matter is to arbitrarily or without just cause deprive the undersigned freedom and security of the person by detaining him without trial in a prison without a roof, on the streets open to all forms of violence from either public or private sources, tortured, enslaved, treated or punished in a cruel, inhumane or degrading way, and the undersigned move in accordance with the Constitution and the law to approach a competent court as a result of his rights enshrined in the Bill of Rights having been infringed or threatened, and for the court to grant appropriate relief, including a declaration of rights that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency, and make an order that is just and equitable. It is submitted that the order was fraudulently obtained following an unlawful and intentional making of false document, court order, or making of a misrepresentation which causes actual or potential prejudice to the undersigned, and in any event, the registrar of the court did not cause a copy to be published as soon as possible in the Gazette as mandated by the obligations imposed in terms of Section 2(3) of the Act. The court's intention is directed to the terms of the court's attention, I beg your pardon, my lord, it's directed to the terms of Section 2(4) of the Act, which provides that any person against whom an order has been made under subsection 1 who institute any legal proceedings against any person in any court or any inferior court without the leave of that court or a judge thereof, or that inferior court, shall be guilty of contempt of court and be liable upon conviction to a fine not exceeding £100 or imprisonment for a period not exceeding 6 months. 6 months has already passed since 6 September 2018 if the court order was to be considered a jail sentence. It is accused that the undersigned is impecunious and did not persistently and without any reasonable ground instituted legal proceedings in any court or in any inferior court, whether against the same person or against different persons. It is submitted that no law may permit arbitrary deprivation of property. The incumbent Judge President Hlophe is an equal person before the law and who shall be called at a later stage to answer or show cause on the allegations leveled against him after the undersigned has written to the office of the Chief Justice to grant consent in terms of Section 47 of the Superior Courts Act, followed by a petition in terms of Section 14 of the Judicial Service Commission Act. After the South African Police Service are compelled in terms of the notice of motion to be heard in the High Court case number 19275 of 2020 to process SAPS case number 1505 2020, registered on 2020 May 2029 May 29 at Kuma Police Station. In simple terms, Judge President Hlophe is a decline in critical capabilities that is removed in terms of Section 77 of the Constitution and must be arrested in terms of the South African Defence Review 2014. The only thing stopping that from happening is that this primary behavior by the registrar to interpret the term court as Judge President Hlophe. Safe to admit that the court staff is somewhat functioning under duress to discriminate the undersigned and grossly violating an imposed obligation that no person may unfairly discriminate directly or indirectly against any person on one or more grounds. The undersigned submits that it does not require a genius to understand the magnitude of this matter, having regard of the elements of the crime committed by Judge President to cause his subordinate to believe that he is the master that must authorize a slave what must he or she must say in court or not say in court. Papa O Teng is not a catchphrase, but a reality informing the undersigned's children, Nico Mangolele and Aluta Songelwa, that their father is there in any event. The children shall want to know what had happened for their father not to be present in their important stage of life to guide and love them as any responsible parent who is lawfully granted parental responsibilities and rights. It is painful to learn that it is the upper guardian of the children's rights being employed as a vessel to separate a father from his children in order to feed greed or corruption to the detriment of the country and its people, and the next generation is being taught that the courts are useless and without the judicial authority of the Republic. Nico is 15 years old and constantly asks why does the court not want him to be with his father, since after having spent almost 4 years without seeing him from 23 January 2016 to 9 October 2019 and spending a night on 19 October 2019 and a weekend on 1 to 3 November in 2019. I pray to the court to be independent and subject only to the Constitution and the law, which it must apply impartially and without fear, favor, or prejudice. It is very tiring to do things as if the courts are not there to serve justice to all people. This matter is not about Lieutenant Commander Sylvester Vulani Mangolele as an individual, but about the service and defense of the country and its people in accordance with the Constitution and the law. This was the matter dated January 2021, 8th of January 2021. And these are the appendix, attachments of the letter. And then I beg the indulgence of court to understand that the averments advanced are as such. In the next proceedings, I will advance the notice of set down that was set down that was to be heard on the 13th day of January and was not heard, to cause us to come to this day. I will ask the leave of the court for the matter to step down and a short adjournment for the next video to be recorded. May it please the court for the matter to stand down, as it pleases the court.